Good morning.
Well, good morning, everybody. It's Monday, March 2nd, Washington Gun Law, live in Denver, Colorado. But most importantly, I am joined by Miss Hannah Hill out in South Carolina. Good morning, Hannah.
Good morning, Bill.
And of course, as always, Kostas Moros out in beautiful Southern California. Kostas, you got a busy morning, brother.
Yeah, man. I'll figure it out, though. Good morning, everybody.
That's what us lawyers do. We just figure it out. You got no other option. Listen, for all of you tuning in, I don't know if we're going to have a big morning or not. I know Kostas is no matter what, because let us remember that shortly at the top of the hour, we do have oral arguments on United States versus Hammani starting, and Kostas will be live tweeting on that on SAF. We are going to be going over, as you all know, we had a conference on Friday. That date is completely wrong. Don't worry about that. But the cases that we are really looking at today are Ducan v. Bonta. That's probably the granddaddy of them all. Magazine ban case coming out of the Ninth Circuit. It's been around for almost 10 years now. Gators Customs Guns for State of Washington, the challenge to Washington's magazine ban. And then we got 3 assault weapon ban cases back on conference. NAGR v. Lamont challenged to Connecticut's assault weapon ban. A companion case of that, Grant v. Higgins. I think this is Grant's first conference on this case. And then a case out of the 7th Circuit, Viramontes v. Cook County. Anyone want to make a prediction?
Yeah, find out if I'm going to be a felon or not. We'll see.
Yeah, well, that's the big deal. That's the big thing with the Ducan cases. Depending on how that goes, you got a lot of people sitting on magazines that all of a sudden couldn't sit on those magazines anymore, right?
Yeah, most likely what would happen if it gets denied cert is after a few weeks, mandate would issue, and then the DOJ would probably give us some window of time, 30, 60, 90 days to get rid of them, turn them in, whatever else. But a lot of people won't. And the Supreme Court, and we made that clear in our amicus brief, by the way, that a lot of people wouldn't. And the Supreme Court needs to do its job. But whether they will or not, we'll see.
Well,
Go ahead,
Jenny.
Yeah, this was GVR'd after Bruin. This is the second time around. That case has done its time and deserves a hearing.
Yeah.
Well, let us also remember Miller v. Bonta, the assault weapon ban case, got GVR'd at the same time, and I don't think we've gotten a full en banc ruling out of the Ninth Circuit panel on that one yet, have we?
Never did. I'm refreshing now to see. We should have an orders list up soon.
Yeah, we're all
right.
Anything happens.
The dreaded delayed orders list. While we're waiting for that to pop up, Kostas brings up a good point about California's magazine ban with possession also being banned. And I don't know if you guys saw this, but the state of Rhode Island passed an assault weapon ban a couple years ago, but only banned the commercial sale. And now they have an amendment to that statute, as I'm pulling up the orders list also, to ban
we got
possession.
a denial in Vincent v. Bondi.
We got a denial in Vincent?
Yeah, I don't know why they took longer on that one.
That's a 922 G1. Is that right, Kostas?
Yeah. I don't know. Remember some weeks ago, a bunch got denied, like a ton of them, and Vincent survived. But now it got denied without any sort of any dissent noted.
That one was also GVR'd though, right? After Rahimi?
I don't remember if Vincent was, if I'm being honest. Yeah,
I believe it was. That may have been why they took longer to deny it.
So nothing on Viramontes, nothing on Ducan, nothing on Gators. Yeah. So those are all getting relisted. Let me look up Lamont.
At this point, I'd be more shocked if we got something. This is just there's a relief in the status quo, a weird sort of dark relief.
That's some sort of a what is this?
It has to do with a prison case. You talking about
so it's nothing relevant to us. Okay.
Yeah, Johnson versus High Desert State Prison.
Yeah. So let me see what else. Grant, did I check Grant?
Grant's not on there.
Oh, that's not gonna. Yeah, it's
nothing
not
on Gators.
Nothing on Gators.
All 5, nothing.
Oh, man.
So another, it's not surprising. I think this is the torture we're going to be put through many, many times.
And it is torture, but I will remind you all of the South Carolina motto, which is "While I breathe, I hope," and that's the most optimistic take on this I can possibly get.
Let me ask you this: if this playing the game of kicking the can down the road over and over and over, they rolled these cases 1 week, and there's yet conferences. Just so you guys all know, the next 3 conference dates are right here. They're March 6th coming up this Friday, March 20th, and March 27th. Why are they just rolling them a couple of weeks when they can easily reset them on a conference maybe 4-6 weeks out?
I don't know. And I've wondered this before. I've asked this many times of people, like if they're going to keep relisting, even if they're going to deny it in the end, like if somebody's writing a dissent, why doesn't it just disappear from the orders list until it's ready and then put it back on the orders list?
That was the thing that I found the most confusing during the long Snope wait. How they kept relisting it like that when clearly they were going to deny it. You had multiple dissents. But they know how long it takes them in the writing process, roughly. They know when it's going to be ready. I don't know why they have to give it a week and just keep it.
Yeah, it's just it's not only that, but I mean, not only is it confusing the viewers for us, but it's just congesting a calendar that didn't need to be that congested on the conference thing, because that a lot of these cases they relist for a Friday conference and then they never get to it. There's no way in hell they even mention it during conference.
Yeah, I mean, I always wonder, like with this stuff, like we're all here stressing, like what did they decide? What did they decide? I wonder how much of it is like, oh, we didn't get to the gun cases again. All right, relist them.
Yeah,
maybe they're just not even talking about them. Who knows, man?
Anyone who's watched legislative sessions and committees in action knows that is a normal thing. I guess it stands to reason the court would be the same way.
Maybe, man. It's very frustrating though.
All right, well, listen, for all of you, all 400 of you watching live now, first of all, thank you very much. For those of you who tune in a little bit later, thanks for checking it out on replay. Ducan v. Bonta, nothing. Gators Customs Gun versus State of Washington, we got nothing. NAGR versus Lamont, we got nothing. Grant v. Higgins, we got nothing. And Viramontes v. Cook County, we got nothing. Those are all going to be relisted. They could be relisted as early as this Friday, March 6th. We are all praying that that's not what happens, because we'll probably have another big nothing burger on Monday. Kostas, you are going to be going live here in a little bit to over at SAF on X. For those of you who want to watch it, you're going to be doing live updates on United States versus Hammani. Let me ask you this. What are you really going to be paying attention to this morning as you watch that argument? What are the 2 or 3 things you are really going to be trying to focus in on?
I want to see, the thing I'm most interested in is what does Alito think? Because he seems like he'd be very skeptical of marijuana and want to disarm drug users, but at the same time, he's one of our most pro-gun guys on the court. So if we're not winning Alito, we're pretty screwed unless one of the liberals is flipping, which who knows? And maybe Kagan would flip on, because this isn't about assault weapons or anything. It's a simple gun possession and marijuana. So maybe she'd be okay with it. So those are the extremes. Watch for if a liberal justice seems to be flipping. I wouldn't count on it, but that would be interesting. And then watch what Thomas Alito, the right-wing guys, think about the weed question. Also, how terrible luck for Hemani, although they never charged him with the Iranian stuff, but like, did that really happen?
Timing is everything, isn't it?
Oh, boy.
So I wonder if...
does Hammani got to go back to Iran for some other funerals now?
Oh, God.
He's going to be back there for a while the way this is going. He's going to be attending. Take a couple of different black suits with you. You might have a lot of funerals to go to.
Oh, man.
Look, regardless of the way the court case turns out, I think we would all be very happy to facilitate his
departure. Well, that's what's got me spooked about one of the cases we talked about last week, which is again, these terrible fact patterns that the United States Department of Justice can kind of cherry pick here.
Yeah.
They did it with Rahimi. They did it with Hammani. And they do kind of get what they want. And the funny thing is that for all of the terrible facts that has to go with Hammani, None of them are actually, the only two facts that are relevant to this whole inquiry is he owns a Glock and they found weed in his place.
And
That's it.
We tried an hour amicus brief, and I know others did the same, to say that, like, hey, I think we even suggested they should dismiss the case and grant another marijuana case, because I'm like, the government's poisoned the well on this, you know, and they haven't charged him with any of this other stuff. And that stuff, you might see a justice like Gorsuch might ask about that. He might beat up the government a little bit. Like, why'd you stuff the petition with all this stuff that isn't relevant because you haven't charged him? You know,
right?
If you want to say he's some sort of terrorist sympathizer, then charge him.
Charge him with some crimes.
Don't
just back off on all that in their reply brief. So maybe they've kind of sensed that they need to do that. It's going to be really interesting to see if they regurgitate some of those irrelevant factoids in the oral argument.
Yeah, I think they knew. They did back off arguing it a lot in the reply. However, I think it's one of those things where they just wanted to ring the bell. You can't unring a bell. So like, let's throw all this shit at him and put that in the minds of the justices that, do you want to arm an Iranian sympathizer, or whatever else?
Absolutely.
Timing is really on their side with this one too.
Yeah.
So there's that.
That was that was a interesting subplot in this weekend's crazy events. It's like,
well, let me give you guys a couple of other things to start. We're going to have to start keeping our eyes on, because I figured I was worried that this is going to be a nothing burger. So I went and I took a look at all the petitions that had just been filed with the United States Supreme Court. We got a bunch, and it's some of the usual suspects and more federal, 922 G1 cases. So local Oregon ordinance that's being also challenged. But there's two in the middle that I highlighted. One is the constitutionality of state laws that permit lawsuits that circumvent the PLCAA, which is becoming a big issue. And the other one is Illinois' open carry ban. And this case right here, this is the challenge to all of these public nuisance laws that these states write to work around the PLCAA. It is NSSF is bringing the lawsuit, but take a look at all the parties that have joined in on this. So this is like anybody and everybody in the gun industry, and you can see we got some big hitters here. And the interesting thing is I've read the brief, and I'm actually I might shoot a video while I'm out here in Denver about it. But the issue, as many of you know, these states literally are passing these laws saying this is meant to work around the PLCAA. Now, we have the case Gustafson that the United States Supreme Court rejected earlier this year. And then, of course, the United States Supreme Court kind of firmly re-announced the PLCAA in the Smith & Wesson v. Mexico case. But the crux of the argument is that if you are intentionally writing a law to circumvent a federal law, that law standing alone violates the Supremacy Clause. Yeah. It's a pretty straightforward argument.
Doubly so when you're clearly also circumventing the federal law for the specific purpose of completely obliterating the Second Amendment. And that's why you see all those gun companies.
That's right.
Because they know what's at stake here.
The interesting thing is if you take a look at the Springfield Gustafson case, which came out of Pennsylvania, made it as high as the Pennsylvania State Supreme Court. When the Pennsylvania State Supreme Court upheld the dismissal of that lawsuit, they said, listen, if you look at the plain language of the PLCAA, it says it bars lawsuits in any federal or state court. And you guys are all writing these state laws, these nuisance laws, these unfair business practice laws. But these are the types of lawsuits you're suing under state law would obviously only be brought in a state court. And Congress contemplated that when they included that language in the PLCAA. That was kind of the reasoning of the Pennsylvania State Supreme Court. The United States Supreme Court didn't want to take another look at it. So it's a real interesting issue because all of these GLOCK suits that you're seeing, okay, where basically you got multiple layers of third-party illegal activity being added onto an otherwise lawful product. These suits are going on. We got them in Seattle, Philadelphia, Chicago. I think they got one in New York and New Jersey. Might have them in both. You got one in California yet, Kostas? GLOCK suit? Or you're just banning GLOCks. You're just going to ban GLOCks.
We don't mess around here. We don't. I was about to curse.
I knew you were. I heard that. I heard that. Remember, it's still a family show here, Kostas.
The People's Republic doesn't litigate.
You don't mess around with that stuff.
Unless you're in Florida, then we litigate.
Well, here's the other case. And by the way, in a lot of ways, I would love to see the Gators gun case get taken for two reasons. Number one, it's near and dear to me. It's a Washington State case, although Ducan deserves it. But you got to admit that if that were to become Supreme Court precedent for the rest of your life to be able to say, well, according to Gators guns, according to the Gators guns case. Now, here's one. Check this out. This is the Illinois open carry ban case, and it is Mississippi Rod and Gun Club v. Raul. Now, how freaking cool would that be to be able to sit there and go, well, according to Mississippi Rod and Gun, that would be great. Now, Kostas, Hannah and I were geeking out about this before you got on air with us. This is what they're asking for. And I wanted to ask you about this strategy. They go through this big challenge, and at the very end of their petition, they're like, hey, we're not asking you really to do a lot of heavy lifting here. What we're asking you to do is just hang on to it, issue your ruling in Wolford, and then kick us on back down to the Illinois State Supreme Court. What do you think of that strategy?
I mean, you gotta take the swing and hope for that, but I don't see how Wolford would be relevant to an open carry case. I mean,
what do you think about the general strategy when you see the court take an issue, trying to rush petitions up there, all in the hopes of literally asking for GVRs out of the deal?
Given how rare cert grants are, I understand why people do that. That said, I don't think the court. I mean, look right now. Hemani's about to be decided, and they just wiped out a bunch of 922G cases, G1, G3. So it's not like they always just hold cases. Oftentimes they don't. A lot of cases I thought would be held for Hemani weren't, which might be bad news for Hemani, by the way. We'll have to see if they think they're not gonna no, we're gonna screw that guy over. So don't worry about it. It's not gonna help,
Right.
But
what do you think, Hannah?
Well, on the one hand, there's a possibility that the Supreme Court would see it as being too clever by half, right? An attempt to game the system, which it kind of is, but they've created the incentive to do that. On the other hand, though, it's a small ask for the Supreme Court. You're not even asking, sir. You're just asking them to do what they're already going to do. And yes, they're going to kick down. I mean, it's not exactly related to Wolford, right? But what we saw after Brew and what we saw after Rahimi was a whole lot of sort of unrelated Second Amendment cases getting GVR'd. That's an out they like to take, and it doesn't have to be specifically relevant. So in that sense, it would be a small ask for them to give us.
I agree. Kostas, I know you got to get rolling. Is there anything else you want to tell the viewers before you go and start getting prepped up? And by the way, in the description box for all of you who are watching live right now, we did link up SAF's X account. So you can hop over there at the top of the hour, get play-by-play from one of the best play-by-play guys in the business, Kostas Moros.
Oh, me? Oh,
yeah, you. You're like the Vin Scully of court cases, man.
Vin Scully wasn't biased though. Well, I guess he kind of was. He was a Dodgers announcer. Right?
He was a Dodger. He was a diehard Dodgers guy, man.
So he was biased. But anyway, yeah. So thanks, guys. Come watch that. Come if you can't listen to the argument, come follow along on SAF's page. Thanks, Bill, for linking it. I don't know if there's anything left to say other than I'm still a little puzzled by that Vincent denial because I really was expecting a dissent.
Especially with not having a dissent, right? If we would have seen it get kicked around and then get denied, but then all of a sudden there's Alito with a dissent on it, then it makes total sense on the calendaring of it. And
maybe somebody was writing a dissent, and then on Friday was just like, I don't feel like
that. To hell with it.
I mean, that probably does happen.
All right, Kostas, we got to let you roll.
Thanks, guys. Yeah, you guys.
All right. Hey, thanks for being here, brother. Thanks so much. Hannah, I'm going to keep you for a few more minutes. All right. Well, hey, do you think we should do this next week, or should we just be like, come on, this is ridiculous?
Well,
I'm going to do it at 8:30 in the morning next week.
I know, right? I mean, that would be, look, my Irish ancestry has me feeling real superstitious about this. If we don't, then what happens?
That's what's going to happen. You remember last week when I realized, like, oh crap, I'm going to be in Denver. I'm going to have to rely on the hotel's Wi-Fi. I was like, you know what's going to happen? The Wi-Fi is going to suck, and Duncan's going to get accepted, and we're going to be like running static off the channel.
True. So maybe Murphy's Law isn't waiting around the bushes to hit us over the head. No, but it's real. I was just thinking, you're in Denver. You're in a state where, for the last few years, the legislature has been systematically gutting the gun industry.
Yes.
And that is exactly what all of these lawsuits that you were just talking about, PLCAA challenges, PLCAA workarounds, that's what they're trying to do on the court side as well.
Yep, and they got a big bill this year in front of down here in Colorado in the legislature that would expand all sorts of requirements for the FFLs, new video recording, audio recording, fortifying the building, new training requirements, new record keeping, making those records accessible to the state upon demand, all these other things that they could then ultimately turn around and sue a gun store because someone had a firearm stolen by a nut job who then used that firearm in an illegal way, and that's the gun store's fault. Right.
And that just really underscores the need for FFLs to be getting involved and to, fight these Second Amendment incursions because they are coming for them next. And I wanted to ask you, it just occurred to me, well, on my desk there, it just occurred to me. So there's two ways you can come at a Second Amendment attack. One is to attack the right itself on the civilian side. You can, all the bans, all the, the carry bans, all the hardware bans, et cetera. The other way you can attack it, though, is to come at the industry and make it and attack the supply.
Yes.
We're seeing a lot more of the latter. Do you think that means the left is giving up on the direct civilian side attacks?
No, I don't think it's that they're giving up. I think it's that they realize that pesky little thing called the Constitution keeps getting in the way of that. And so what they're doing is you're seeing three things outside the what I would call direct frontal attacks on the Second Amendment. Okay, you're seeing trying to eviscerate the FFL industry.
Right.
You're trying to see making the access to the Second Amendment financially prohibitive to people and also chronologically burdensome to people. All right. So you make it for the individual, you make it really expensive and very time consuming. You're going to get a lot of people who are just going to be like, the hell with it. I don't want to do it. And then what you do is you crush the FFL industry. And I want you to think about what's happening. Like, let's take a look at what's going to happen in Virginia. And this is why I want everyone in these states to be aware of what's going on. You're going to systematically remove magazines and semi-automatic rifles from the inventory. All right. So now their revenue opportunity goes down. And if you really understand the industry, you know that some items have good markups. A lot of items in the FFL industry have paper thin markups. And if you don't believe me, take a look at the retail price of something, take a look at the online price of something, very little difference. Okay. So you take away the revenue opportunities, then you add cost to their operation. We're going to make you dump $25,000 into your building and in retrofitting the infrastructure and all that. Then we're going to make you spend an extra $10,000 in training. We're going to make you spend an extra $20,000 a year in labor because you got all these extra things you need to do. And so now you've lowered the revenue, increased the cost. What happens to those businesses? They go out of business. Here's the worst thing and the most sinister thing about it. And I've already seen this in Washington. We're seeing this in Oregon also. The Cabela's and the Bass Pro Shops of the world that operate in the big cities, doesn't bother them in the slightest. They don't care. All right. And the truth is you can have a Cabela's in Alexandria, Virginia losing money because there's 3 of them in Arkansas that are printing money. Okay. So they can do that. What it is, it's Joe's gun store. And Joe is the grandson of the Joe who started the thing. And they've been serving a rural community out there for 75 years. And they're the ones that go under. And all of these little small mom and pop independent FFLs around the rural parts of the states, they all go under. And then what you end up with is what I call Second Amendment deserts, where literally you could live in a rural community and you got 75 miles each way to go see a gunsmith. And that's exactly what they're trying to create. And ultimately, they're going after the people who are most dependent upon the Second Amendment, not only for self-preservation, but for self-sufficiency. Hunters, farmers, things like that. That's who ultimately gets the most affected immediately by it.
And honestly, that's the only way you're going to get through something like that on them. In many areas, the heartland of America, depending on how much, obviously the cities are the ones that are going to be cracking down on the Second Amendment the most easily. It's going to be the rural areas where you have that understanding of what the Constitution is there for and what it means in terms of gun rights. So to attack the supplies in a diabolically effective way of taking away their rights.
Yep. So what are you hoping for? Are you hoping that NAGR Lamont gets relisted for Friday, or you want to see that just get punted all the way down to like that March 27th date? Wouldn't that be better?
Yeah, it would be better for a lot of reasons, the logistical reasons for all of us, not being the least of which. But no, honestly, I kind of echo Kostas. I've never figured out why they just kick it down the road from week to week. If they're already going to do that, just, give themselves a break, give all of us a break. Take the time they need to write whatever dissents that they're writing. I would love to get a GVR after Wolford. I would really, really like to do that. And I think, so Viramontes' record is not the best. And I would
No,
have
it's
thought that
kind of
one-
non-existent,
Right.
actually.
I think that one's still alive because it's in a group of 5 hardware bands. So it seems like
But let's remember yours and the Grant case are also in an interlocutory phase.
they are. Again, though, you've got a bit more of at least procedural history there that's significant. And Ducan and Gators guns are certainly in a good situation as well.
Ducan and Gators are both in really good shape from a
Right.
record standpoint. Gators, we tried that case down in Cowlitz County. It was a 2-day trial.
Mhm.
It was the full deal. And then of course, Duncan's got a record that if, it would fill this room with paperwork. The
Yeah.
record that's been made on Duncan, right?
Yeah.
So
I mean, the thing is, I think, if it had been just one of any of them, then, we would have seen the case disposed of before. Now it's
Yeah.
a group of 5, and the Supreme Court's keeping all of them alive regardless of their procedural health, right?
That's
That
true.
seems to indicate that they're taking something seriously, that they're at least toying with something. Then again, they know Cheeseman's coming up from the Third Circuit. That's a solid chance to get the circuit split.
Yeah, that's the one. And for those of you not familiar with that, Cheeseman v. what Hannah's referring to is Cheeseman v. Platkin. It's a case out of the Third Circuit, challenged in New Jersey's assault weapon ban. Procedurally, some really goofy things happen that if you are a proponent of the Second Amendment, you would be sitting there going, oh, I like what's happening here. The en banc panel coming in and taking the case. And if you listen to the oral arguments, you're like, seems like most of the justices seem to be on our side. If Cheeseman were to come down and strike down New Jersey's assault weapon ban, the entire playing field changes overnight.
Right.
Because now you got the state of New Jersey crapping itself, filing a petition to the United States Supreme Court immediately.
Does that include a mag ban as well as the gun ban?
Yes, it does. Yes, it does. And then you got a circuit split. I mean, I think if we're going to do something with this group of 5 right now, Hannah, what the court would do, and this is, I could be totally wrong on this, is they would take Ducan and hold the other 4.
I wouldn't hate that, honestly. I mean, I
No.
know it's our cases, but I would not hate that.
No,
They
that would.
can't uphold mags without
As
also
far as what
upholding
we
the
can
gun
get
itself.
is what we're actually realistically could get. That would be almost the best case scenario.
It would. All right, so let me throw one other curveball. Do you think
boy.
Do you think they're waiting for Miller? You brought that up out in the California.
I don't think they're waiting for Miller because they could be waiting 5 years for Miller. I think
That's
they know
true.
that the Ninth Circuit is completely. I think it's a great question. I just think that they know that the Ninth Circuit is so into gamesmanship that they're
Mhm.
not going to do that. But let's remember that the Third Circuit traditionally is pretty quick about its rulings. And let's remember that the en banc panel took this case, thus showing clearly that they had a big interest in it.
Yeah.
I'm a little surprised we haven't had a ruling on Cheeseman yet.
You think
And
it could be
I
that
would
soon?
not be shocked if it came out. Friday would be a good day. Give me something to
Friday'd
talk
be a
about
real
over the
good day.
weekend. It would also change the conference on Monday big time, wouldn't it?
Yes, it would.
Right?
That would be a very different conversation Monday if Cheeseman had come out between now and then.
It'd be very different because I can assure you that we would not, the one thing that would not, if Cheeseman came out on Friday, the one thing we would not get on Monday is a denial in any of these 5 cases.
Yes.
There's
Yes.
no way we'd get a denial. They would hit the pause button and be like, all right, because again, they would sense too that the entire world had just shifted under their feet when it comes to these particular issues.
All right,
Right.
so let's play that out from a procedural standpoint because, all right, they have to have time to take it to appeal to the Supreme Court.
Mhm.
And then there has to be time, months for briefing, right? Each
Mhm.
side's going to be briefing. You're going to see all the amicus briefs on search. Is there any rule against them, just keeping all of these 5 cases on ice?
Oh yeah,
Well,
they could do that. Here's what if the Supreme Court were to listen to me, which they will not, but if they were, I would tell them, like, let's say you got Cheeseman coming up to the court, right? You take Ducan and you just sit on the other 5 because you'd have the 4 left over of the original group of 5 plus Cheeseman.
Right.
You just sit on those 5. You go ahead and resolve Ducan. You're going to rule on the common use test. You're going to hopefully clearly announce what common use means, even though it's been announced in multiple cases. But apparently we have to do it again. And at that point, you GVR the rest of them back. Do I think that we might end up with a situation where the courts are like, oh, well, we're just going to come around with a workaround this way? Yeah, I do think we'd end up with that. I do. I mean, do you really honestly think that the Ninth Circuit would begrudgingly be like, all right, California, you're going to have to put those back on the shelves now?
You know, it is possible pigs could fly. It is possible.
Yeah.
Do I think it's likely? No, of course not. It's the Ninth Circuit.
All right. Well, listen, for those of you who just tuned in, thank you very much. All 440 of you watching live right now. Kostas has departed. He is over getting ready for the big arguments today. For those of you who do not know, United States versus Hammani is going to be going live in about 3 minutes. So we're going to log out here in just a second. Quick update. Ducan v. Bonta, nothing. Gators Customs Guns v. Washington, nothing. NAGR Lamont, at least we got a hill here to talk about it, but beyond that, nothing. Grant v. Higgins, big nothing burger. Viramontes v. Cook County, big nothing burger. Our next conferences, we got one on Friday. We'll see if they're going to, if none of the group of 5 cases go to the conference on Friday, we will not be doing a WGL AM on Monday because there wouldn't be anything to talk about other than you and I just trying to solve all the world's problems, Hannah.
Which, I mean, we could do it between the two of us.
We could try.
We
could try. Hey, let me remind all my good friends out there in Illinois that Washington gun law is coming out there this weekend. This is our road trip schedule. March 7th and 8th, we're going to be up at GAT Guns for the factory shoot. And then we're going to start working our way on south. Streeter, Bartonville, Bloomington, Quincy, East Alton. I'm actually flying back home from St. Louis, Missouri, Hannah. So I fly into Chicago and meander my way on down. And I'm going to do a little Kirk family research because the very first Kirk to ever come to the United States, hopped off a boat in Nova Scotia in the 1850s, was a farmer outside of Springfield, Illinois in the 1860s before he enlisted in the Union Army to go fight in the Civil War.
Oh,
so
that's fascinating.
The Kirk family actually comes out of Illinois.
So way back to the roots then.
Way, way back. And you know how we ended up in Washington is after the Civil War. Dude was a bit of a badass, I guess. I got the books on him. He was a very good soldier. He was given 40 acres of land by the United States government for serving the country. They gave him 40 acres. Cool. Yeah, but the problem was the acreage was out in the Washington Territory. So 1883, hopped on a wagon train, wife and 2 little kids, made it all the way out to Elmira, Washington, not far from where the Grand Coulee Dam is.
Oh, that's so cool.
That's where the original Kirk homestead in Washington State was set up. And since that time, every single Kirk on my side of the family that's ever lived in the United States, every one of them is actually buried in Washington State.
Oh, man. Well, you know, there aren't many families that can trace your history quite in that way. That's fascinating.
Yeah, and it's also very infuriating when you sit there and you start talking about the fact that you may have to leave the state because it's becoming unlivable, right? You know, you got hundreds of years of lineage sitting there, and now
generations.
It's like, yeah. How nice is it for you to be back in South Carolina now?
Oh, super nice. Super nice. This is where my family's been for many generations as well. I don't really want to talk about what my ancestors were doing during the Civil War, but, you know.
That's all right. That's all right. We could, you know, I understand.
Yeah.
So, all right. Listen, well, thank you so much for joining us today. I appreciate it.
Oh, well, thanks for having me.
I hope you have a very productive day. I'm going to go down the street and yell into a megaphone at 11 o'clock with Ian Escalante at RMGO.
Nice. Give them what for.
Huh?
Give them what for.
Exactly. All right. Hey, listen, for all of you who tuned in or all of you who are going to check it out on replay, thank you very much. Illinois, I will see you guys next week. If we go live, I will be in Chicago. We will do it. We'll see if these cases get relisted. If not, we'll be back probably one of the other Mondays when the group of 5 cases gets back on. Hannah, thanks so much. You're the best.
Thanks so much, Bill. Always a pleasure.
All right. You take care.
All right.